California foreclosure laws must be changed. Homeowners Need a Voice by Carmel Rowe. Between 2008 and 2012, California had more foreclosures than any other state. On an average, 500 families a day had their homes illegally foreclosed on by lenders, or should I say pretend lenders. The California government and the California judicial system was ill-equipped to deal with the meltdown of 2008. Judges were not trained, and government did not act swiftly. This resulted in more foreclosures than you could imagine. Let's take a look at what made the meltdown of 2008 possible. In 1999, the Gramm-Leach-Bliley Act was enacted. This allowed banks to sell mortgage-backed securities. What this means is that a bank was able to realize face value of the loan times 1.5% immediately. So if you took out a $100,000 loan, the bank was then immediately able to collect $150,000, deposit that money into the bank, and then lend 9 times that amount, which is $1.35 million roundabout. Prior to the enactment of Gramm-Leach-Bliley, banks were only able to realize 2.5% of the face value of the loan over a 30-year time span. The Gramm-Leach-Bliley Act made banksters and banks very greedy. Underwriting guidelines were relaxed and thrown out the window. Basically, anybody with a pulse could purchase a home. Banks were now able to securitize mortgages, and they did. They took full advantage of this. What they did was they placed them in pooling and servicing agreements and interimic trust, registering them with the SCE. Once the loans closed, they quickly packaged them and sold them on Wall Street. Secondly, once they sold them on Wall Street, the negotiable instrument, which is your deed of trust, was turned into a stock. So basically, if I have 100 oranges and I stick them in a juicer and I juice them, what I get back is a whole bunch of juice. I don't know which piece of that juice belongs to what orange. So then I put it in bottles and then I go and I sell it to hundreds of people. Basically, this is what they did with your mortgage. They placed it in this RIMIC. They placed it on Wall Street. They sold these pieces to thousands of different investors. Therefore, by doing so, they converted the negotiable instrument, which was the deed of trust, into a stock, and it is now regulated by the SCE. The security is forever lost, which means banks can no longer foreclose. They know this. But however, in California, they have been illegally foreclosing on homes because we have no judicial oversight. In recent years, since the Gramm-Leach-Bliley Act was passed, 85% of foreclosures have been done illegally. Ted Rieska, 2013. Foreclosure reform is necessary so history does not repeat itself. The pandemic has put homeowners in a pickle. Once the CARES Act is completed and unemployment benefits are no longer, we may see another 2008. Even worse. We need to place foreclosure reform in effect now. We need to give homeowners a voice by enacting judicial foreclosures with court oversight. We need to train our judges. We need to give our homeowners a voice. In California, illegal foreclosures is the norm. Banks continue to take homes even today, to this date. Yes, some of their practices have gotten better. They've paid fines. But since 2008, illegal foreclosures have become the norm. Because of California government and California courts have failed to hold banks accountable. They have failed families and failed to give homeowners a voice. Statistics have shown that Latinos and African Americans were hit the hardest. 48% of all the foreclosures in California were to Latino families. I've been in real estate for over 25 years. I've also done mortgage loans. Today, those underwriting standards that were put back into place are slowly becoming relaxed over and over again. Making California a judicial state would shift the burden of proof from the homeowner to the lender. It would also force the bank to file a court action and get judge approval before a foreclosure could take place. This would give homeowners a voice. This would give homeowners a chance to present their information or to present their defense to the judge and allow the judge to decide if the foreclosure is legal or illegal. In judicial states, judges are educated because this is something that comes across on the norm. This is not something that, one homeowner decides to sue or one attorney or this and that. No, this is something that regularly happens during every foreclosure, so they know the laws, they know what to look for, and they are trained for these things. Having California a judicial state would establish a new set of foreclosure laws. It would also help set case precedents to establish that homeowners can challenge a foreclosure prior to their home being foreclosed on. This would cut down the amount of illegal activity that banks are allowed to do. The main difference between a judicial foreclosure and a non-judicial foreclosure is the court oversight. In California, lenders are allowed to do illegal activities over and over again with no oversight from anybody. In a non-judicial foreclosure state, the lender must contact you and give you 30 days to respond. If you fail to respond, the lender may then, or cure the defect, the lender may then file a notice of default. The lender must then send you within 10 days a certified copy of that default and or post it on your door. After 90 days have passed, a notice of sale may be recorded, and within 21 days, the lender is allowed to enable the trustee to sell your home on the courthouse steps to the highest bidder. You have no redemption, and the only recourse, if you do have any, would be to sue after the fact for money, not for your home. It's virtually impossible to get your home back after foreclosure. In a judicial foreclosure state, the bank must first send you a letter of intent. If you fail to cure or you fail to respond or you guys fail to negotiate, then the lender may file a lawsuit. Once the lawsuit is filed, they must serve you with the summons and complaint. Once you're served with the summons and complaint, you have usually between 20 and 30 days to answer. If you fail to answer, the judge will side for the bank and your home will be foreclosed on. If you do answer, you will have the opportunity to present your facts and to show the judge why your home should not be foreclosed on and how the foreclosure that the lender is trying to enact is illegal. If the judge sides with the bank, then the home will be allowed to be foreclosed. And once the home is foreclosed in a judicial state, you have a 1-year right of redemption, which means anytime within the first year after the home is foreclosed on, you can pay all the money plus interest and you can redeem your home and have it back. So there are pros and there are cons. In a judicial foreclosure state, you can obtain the lender may obtain a deficiency judgment, which means if you borrowed $120,000 and the bank sold your property for $100,000, they could come after you for $20,000. However, you also have the right to speak and to redeem your property. You then have a voice. These are all pros. California should enact judicial foreclosure laws so that homeowners in California are not illegally foreclosed on. California laws must be reformed now. We are about to go into a crisis. California homeowners need a voice before their homes are foreclosed on, not after they're foreclosed on. By changing California's foreclosure process to a judicial one, homeowners will get a voice, judges will get the training they need, and banks will actually be forced to follow the law. Californians, please stand with me. Call your state representatives. Ask them to make a change. Ask them to enact foreclosure laws, making California a judicial state. Thank you. Before we see 2008, only worse.